Muted.
Or he can executively order anything that Congress has explicitly authorized him to do. But if he goes beyond those boundaries, then his executive order would be subject to challenge in court.
Thank you, Hemant.
Muted.
Talking about a lot of legislation, some of these legislation that has been introduced in the 115th Congress, and there have been all this coverage about the H1B proposed new H1B rules. Could you kind of elaborate what's basically happening in Congress at this time?
Sure. So there are 4 bills that have been proposed in the current session of Congress. And this is actually a topic that has been kicked around a little bit over the past several years. So this is not new to the Trump administration. But, you know, because of the renewed focus on immigration, it's likely that, you know, one or more of these bills might be enacted into law. So there's one bill that has been introduced in the Senate by Chuck Grassley and Dick Durbin, who are 2 fairly high-ranking members of the Senate. And there are 3 bills that have been proposed in the House, which is the lower house. So I'll summarize these for y'all. So first, the Grassley-Durbin H1B and L1 Visa Reform Act of 2017. This is a bill that has been introduced into the Senate, the upper house. And the 2 sponsors, Chuck Grassley and Dick Durbin, are fairly senior members of the Senate. They are ranking members of the Senate Judiciary Committee, so they have a considerable amount of influence on immigration policy. And they have been trying to push this bill for a few years now. So some of the main things that it does is it affects the H1B lottery. So, you know, normally the current system that we have now is we have the lottery every April, where the 65,000 visas are randomly allocated to various applicants who apply at that time. Instead of the lottery, the Grassley-Durbin bill would replace that with a list of priorities and prioritize applicants who are closer to the top of the list. So if you can look at the slide, you will see that the slide essentially prioritizes the chart essentially prioritizes people who either have advanced degrees from U.S. institutions or will be paid at the highest wage level. So those are the H1B petitions that will be prioritized. So the highest priority will go to advanced degrees in STEM fields from U.S. institutions, and highly paid workers at the highest wage level will follow them. Advanced degrees in non-STEM fields from U.S. institutions will follow, and then the second highest wage level will follow them. And then you'll have bachelor's degree holders from U.S. institutions, and then as you go down the list, you see the rest of them will be listed. But essentially, this would prioritize certain more qualified H1B applicants over those that are considered to be less qualified. And some of the other things that are accomplished by this bill is fairly comprehensive, so it addresses a lot of issues. But one thing it'll do is it'll enhance the authority of the Department of Labor to be able to review and investigate and audit employers who are sponsoring the H1B or L1s. And in order to fund this, they will require payment of additional fees as part of the application that would fund the Labor Department's ability to do this. This bill would also address L1s. So employers who bring L1s from overseas to here would face having to pay higher wages. It would introduce a wage floor for L1s to make sure that their wages are competitive with U.S. workers. And it would also tighten the penalties that would have to be assessed for willful misbehavior of L1 employees. There will be tighter rules across the board. So the specialized knowledge that an L1B holder would have to hold in order to qualify for that visa would be a stricter requirement. And essentially what would happen is that it would not terminate either of these programs. The H1B and L1 program would still continue, but it would be a major overhaul, and the general requirements would be stiffer. So employers would have to jump through a lot more hoops. They would have a lot more regulatory burdens that they have to clear. For example, there may be more recruitment steps and things like that to make sure there are no U.S. workers available. And it would specifically target employers who have 50 or more workers if more than 50% of them are on H1B or L1 status. So the large Indian outsourcing companies like Infosys and Tata and companies like that would have to radically modify their business model in order to comply under this new regime if this bill passes. And it would also make it much more difficult for H1Bs who have degrees from India, without as opposed to degrees from the U.S., or who are applying for lower paid positions to be able to obtain U.S. employment. The next bill that I'll be covering, the following three bills have all been introduced into the lower house, the House of Representatives in the legislature. The first one is by California Congressman Darrell Issa, the Issa Peters Protect and Grow American Jobs Act. This one is much narrower in scope than the Grassley Durbin bill that I just discussed, but in that it only focuses on H1B visas. But it tries to address the same issue, which is that it wants to make sure that H1Bs go to employees who are more highly qualified and will be paid more. So it raises the salary requirement for the H1B from $60,000 a year to $100,000 a year. So anyone who is applying for an H1B that will pay them under $100,000 a year, the employer would have to make sure that there are no U.S. workers available. And currently there is the master's degree exemption, where an H1B with a master's degree can be hired without the recruitment step. That exemption would be eliminated. But the current laws regarding H1B dependent employers and how the rules apply to them, they would not change. But the goal of the bill would be similar with respect to H1Bs, in that it would make it more expensive, more burdensome to get H1B employees. There would be more steps that an employer has to take, and it would be more difficult to fill lower paying jobs with H1B workers. The next bill that I'm going to discuss is the Chaffetz bill. It's introduced by Jason Chaffetz, who is a representative from Utah. It's called the Fairness for Highly Skilled Immigrants Act. This is one that, like I mentioned before, some of these proposals have been floating around for a while. So this has been introduced into Congress for the last 3 or 4 years. So it predates, the Trump administration and all that. But this one actually addresses immigrant visas. So the EB2, EB3, those visas that you would gain in order to get a green card. This actually addresses them. And in a way, it could be beneficial to Indians in America who have these kinds of visas, because it eliminates the per country cap for employment-based immigrants. So currently, if you have an EB2 or EB3 visa, you have to wait until your priority date becomes current. And for an EB2, that can take, upwards of 20 years, depending on, how quickly or slowly they keep advancing the priority date. This would eliminate that cap, and it would replace the cap with the first come, first served visa system. So this would actually potentially greatly benefit Indian EB2 and EB3 holders, because it would allow the people with older priority dates to get green cards more quickly. And finally, the bill that has been proposed by Zoe Lawford, a congresswoman from who represents Silicon Valley in California. This is a Highly Skilled Integrity and Fairness Act of 2017. This has largely the same goal as the Grassley, Durbin, and Issa bill, which is to increase the quality of H1B visas. So to make sure that H1B visas go to people who will be paid more, who deserve to be paid more. So this one actually institutes somewhat of a market-based approach. So what it'll essentially do is it'll prioritize H1B visas for people who are going to be getting paid higher wages as compared to the prevailing wage. And the prevailing wage itself would be calculated slightly differently. It would be calculated based on geographical area in addition to the quality of the job and things like that. But then essentially, the H1B would be granted to people who are getting paid a higher percentage of that. It would also address certain other issues around various immigration programs. So for F1s and even for H1B filing requirements, it would remove certain hurdles. It would streamline the process a little bit by which those are obtained. And like the Chaffetz bill, it would also remove the per country cap for EB2, EB3, employment-based immigrant visas, which would hopefully allow Indians with older priority dates to get green cards more quickly. And to go into a little bit more detail about how the Lawford bill would work with H1B visas, the prevailing wage requirements would be more geographically based, and there would be 3 levels by which the wages were calculated. And once they calculate the 3 levels, the H1Bs would be awarded in order, but to employees who would be getting paid higher percentages of the higher wages. So as you can see, the H1B would be prioritized for people who are getting paid 200% of the level 3, the highest prevailing wage, and then it would go down the list down to people who are getting paid 150% of the level 1, the lowest prevailing wage. So essentially, this bill would act similarly to some of the other bills that I discussed, in that it would make it so that H1Bs are granted to people who will be paying more to their employees, and in that way, the idea is that it would protect the U.S. workers who would qualify for some of the lower paying positions. Now, to summarize, none of these bills is guaranteed to pass. It is most likely that if any of them passes, they will pass in a considerably different form because, like I mentioned before, these bills, once they're introduced, they have to go through the committee, then they have to be voted on by the entire House, and both houses have to pass them before they go to the President. And of course, the Trump administration, being somewhat hardline on immigration, they can also exert influence during this process and try to make these bills a little bit tougher, change the language in the bills and things like that. So, but if any of these pass, there's a few things they seem to have in common, which is that they are going to make it harder to obtain H1B visas, especially for people who have foreign degrees as opposed to U.S. degrees, and especially for people who will be getting paid lower wages. And employers will almost certainly have a more difficult application process. So there will be more recruitment steps and things like that under any of these bills than there is under the current system. It is also quite likely that employers who rely on L1 visas will have more steps as well. There will probably be wage requirements. There will probably be other compliance procedures and things like that. And the most likely people who will be affected are H1B dependent employers, so employers who have large percentages of H1B workers. Large consulting companies that are known for outsourcing, like Infosys and Tata, and H1B workers who don't have U.S. degrees, and positions that are lower paid.
Thank you, Hemant. That was very illuminating and a nice summary of all the H1B proposals that are sailing through Congress right now. I hope that we don't see any of these bills becoming actual law, and I think that with Trump just basically becoming president, he would want to basically put his own mark on immigration, and these are bills that have basically been there for quite a long time. So it's kind of debatable whether we are going to basically be seeing the actual passage of these bills at this time. It's possible that some of the main provisions of the bill could basically be taken and woven into a comprehensive bill that the Trump administration chooses to pass at a later stage. But right now, I'm kind of skeptical whether any of these bills are actually going to be legislated into law. Now, Michael, I know that Trump basically has been trying to hire some of his cabinet picks for various positions in the government. And could you basically explain, for the benefit of our audience today, who his cabinet picks are for some of the important positions that impact immigration, and what are these cabinet picks' views on immigration or on labor enforcement? Can you elaborate a little bit on that, please?
Yes. So just as with every new president, Trump needs to fill out his cabinet, with leaders of agencies, people to help him execute the laws and, lead the country in kind of the way he sees or views what he wants. There's a number of kind of key figures in terms of immigration agency officials. Probably, maybe the most important is John Kelly in terms of, the scope of immigration law enforcement. And one good thing about looking at these agency heads, cabinet members, is that at least right now we don't really know what Trump is going to do. Sometimes he says contradictory things. So looking at who he's selecting for his agency heads can hopefully shed some insight into what he wants to do going forward. So John Kelly is kind of an interesting character in that he's one of the least controversial cabinet members. He received bipartisan support and, was confirmed pretty easily without any opposition. And within his first week on the job, there's actually, some trouble that he and Trump had with each other. Trump really wanted Chris Kobach to be Deputy Secretary of Department of Homeland Security, and Kobach's he holds very extreme immigration stances, very hardline stances. Kelly did not want him to be Deputy Secretary, maybe just because he wanted to select his own guy, but either way, I think that's good that he's not being influential on immigration decisions. There's also some issues with Trump's recent executive order in terms of the travel ban. Kelly had known it was in the works. He had requested details and never got any, and it was issued without him even being able to review it, so that caused some problems. So as you see, there's some kind of potential risk that has developed between Trump and Kelly that maybe, could prevent him from just doing everything that Trump wants, or at least, not putting up any sort of opposition. But at the same time, he's also known for being very strong on immigration enforcement, especially like with border security. So not exactly sure, but I think there's a little bit to go on there. Another key figure in Trump's administration is going to be the Attorney General, and that office is very important because they're the chief law enforcement officer of the United States. Their duties are to prosecute and conduct all suits in the Supreme Court in which the U.S. shall be concerned, and to give his advice and opinion on questions of law when required by the President or when requested by heads of any departments. So he's essentially kind of in charge of figuring out what kind of cases, issues the U.S. government is going to prioritize. And throughout his political career, he's a senator right now. He's been nominated for Supreme Court, but got rejected based on some statements he's had regarding race. So he's had a controversial career, but one thing he's been known for is his stance on immigration. He's very opposed to legal immigration, and he's also advocated for reducing legal immigration. So that he might not be, as influential in terms of policy, but in terms of enforcement, he's going to have a very large role. So I think that can be indicative of what we'll see with the Trump presidency. Another key figure is the Secretary of Labor. nominee. I should say Sessions as well is just a nominee. They haven't been confirmed yet. Both probably will be confirmed. But Andrew Puster, he is the CEO of Hardee's Carl's Jr. fast food restaurants. He's been known to be a strong opponent to raising the minimum wage, a lot of, government oversight of employers and worker protections like overtime laws. So some people have kind of questioned his choice for this position, as it's supposed to be protecting workers, and so he's that's not really his view. He thinks there should be less government oversight. He's actually received a little bit of criticism from conservatives in that he's in favor of immigration reform, but he's also made statements in support of immigrant workers, and he's been opposed to kind of those mass deportation proposals Republicans have had in the past. So he's not the most hardline anti-immigrant person, but he's also very pro-employer, and because of that, his view, I think, would be to limit government regulation, oversight, interference in the workplace, which, could potentially mean less regulations, procedural hurdles, but that's kind of at odds with what Trump seems to want to do. And I think if that were to happen, Puster were to get his way, it could potentially lead to more exploitation of workers. So the last figure, who we really don't know much about his stances on immigration, is Rex Tillerson, who's been confirmed as the Secretary of State. And Secretary of State is the highest ranking member of the cabinet and the third highest official in the executive branch behind the president and vice president. And as you can see from the slide, he does serve a number of duties that involve immigration, but more so in terms of kind of just foreign affairs. But if Trump were to release, as he recently did, controversial executive orders, it's kind of on Tillerson to be the person to smooth out foreign relations, which could go a long way in, making sure things go smoothly and there aren't a lot of uproar in the international community.
Now, Michael, since Trump became president of this country, he has been kind of silent on legal immigration reform. And it's basically, he has been keeping it close to his chest.
Mm-hmm.
We haven't heard a whole lot about the legal immigration reform. We have seen executive orders on the travel ban for the 7 countries, which has basically been called the ban on Muslims, travel ban on Muslims. Now, as far as the legal immigration reform is basically concerned, what do you think? How do you think that the whole thing would basically play out with Congress, with piecemeal legislation versus comprehensive immigration reform? Would he pursue his own goals by issuing executive orders? Would he basically be receptive to the needs of the tech industry and the Indian IT industry? Would you kind of elaborate a little bit? I know that it's all probably, no one can, we don't have, we are not like fortune tellers, but can you basically see how this whole thing could go?
Yeah, so Trump, as I mentioned earlier, his main goal as a president is to create jobs, bring back jobs to America. And that obviously implicates immigration law. So I think, and as we'll discuss later, he's had some draft executive orders that I think shed some light on his views and what he wants to do. I believe he will want to make pretty comprehensive changes. I'm not sure how much he'll actually be able to do. He's limited to certain enforcement measures and essentially directing his agency heads to make regulations, and those can take a long time, and as the public can comment on them and the government has to respond to those comments, they might not turn out the way he wants, depending on the responses. He can push for Congress to pass legislation, and it's possible that they might, and whatever Congress passes, he's happy with. But as we're going to discuss in just a moment, at least from his draft executive orders, it seems what he wants is more comprehensive and goes even further than what's been proposed in Congress. So I'm not exactly sure if he will be content with whatever Congress does. And in terms of meeting with stakeholders, if he really is interested in protecting, American workers as a businessman, you think he's going to want to get the best deal that he can for U.S. workers, which would mean getting the most information possible. But there's also been reports that he hasn't taken all information into account when making certain decisions. So, like everything with Trump, it's a bit of a guess, but I'd like to think that he's going to do something that's going to be good for the U.S. workers and hopefully not too detrimental to foreign workers, but I'm not sure.
Well, thank you, Michael. Now, we have seen quite a bit of coverage on the congressional bills, but we haven't really seen a whole lot of coverage, at least not to my knowledge, on the Trump's draft executive order. That, for some reason or the other, I don't believe that the press has played up a whole lot of it. Is it possible that you could go into Trump's draft executive order concerning legal immigration?
Sure. So one thing that we should know about these draft executive orders is that they've been leaked. These are not official. These are not final. But from Trump's office, from somewhere in the government, these have been leaked to the media, and the media has published the contents of these draft orders. So the only order that has been signed that we know of is the so-called Muslim ban order. But these other ones targeting legal immigration, these are ideas. And normally the procedure is that when an executive order is drafted, you would have to submit that to the Office of Legal Counsel, and the Office of Legal Counsel would have to make sure that this complies with whatever the president is allowed to do legally. So, one of the orders that has been leaked, is protecting American jobs and workers by strengthening the integrity of foreign worker visa programs. The language says that it wants to ensure that officials administer the law in a manner that prioritizes the interests of American workers and to the maximum degree possible the jobs, wages, and well-being of these workers. Now, when you look at that language, it seems like it would really want to direct the various agencies like the USCIS to overhaul the regulations that currently apply in a way that really prioritizes American workers. So to this point, immigration law typically tries to strike a balance between protecting American workers and being beneficial for business people and the economy as a whole. But Trump is certainly trying to push this based on the draft executive order language. He wants to push this much farther in the direction of American workers, and less so in terms of, what might be, what might benefit, what business people might want to do. And some of the other language in the executive order is that for H1B visas, they want to make sure that beneficiaries are the best and brightest. This is the language that was there in the leaked executive order. And this is very different from the current requirement, because under the current requirements, an H1B, to qualify for an H1B visa, you have to have, you have to satisfy whatever requirements they have. So, you have to be, whatever the case may be, a bachelor's degree and a certain amount of experience, or master's degree, whatever the case may be. This is a substantial departure from that, in that it really raises the standard of who actually gets to qualify for an H1B visa. So it is likely, I was discussing the bills that have been proposed earlier. Some of those kind of try to get at the same thing, in that they want to make sure H1Bs go to people who either have U.S. master's degrees or are getting paid at the highest wage level. So it's based on the language of the executive order, it seems that the Trump administration wants to do something similar, where H-1Bs go to only the most qualified candidates, and that those who are less qualified, those who get paid less, those who have lower degrees, might have a harder time getting H-1Bs under the new regime. And they may also they could increase salary requirements to do that. They could limit the H-1Bs to professional workers, or introduce additional recruiting steps that businesses would have to undertake before they can get H-1Bs.
Now, Hemant, we have over 1 million foreign students here in the U.S. studying in many thousands of educational institutions all across the U.S. And Trump's draft order, at least that has been leaked, it seems to contain some important information on the F1s and OPTs. Could you basically let us know what Trump's plan is for these F1 and OPT students?
Sure. If you look at the draft executive order language that we've quoted here, it wants to issue regulations that would reform these OPT type of programs for foreign students that would prevent the disadvantaging of U.S. students in the workforce. So again, we see the emphasis on U.S. workers, regardless of how it affects the foreign workers who might want to take advantage of these programs. So there are over 1 million foreign students in the U.S. Most of them will apply for OPTs and STEM OPTs. And what is likely to happen is that Trump will likely reduce the length of employment authorization under these programs. So, currently you have the extra 1 year training under the STEM OPT program. It's possible he may target that. He may create other rules that make it harder to get these to get STEM OPT authorization and things like that. So, it's likely overall that it's going to become more difficult to qualify for these types of programs and more difficult to get as long of a period of time. And while we're on that subject, I also wanted to address, one issue that has come up recently. This is actually before Trump took office, but it's an issue that affects a lot of foreign students in the U.S., which is that ACICS, which is an accrediting organization, was recently derecognized by the Department of Education, which means the universities that were previously accredited by ACICS, such as, for example, Stratford University, there are a few other ones like that, I think University of Northern Virginia. Some of these universities out there that used to be accredited by ACICS are no longer accredited by them. And what that means for them is that they cannot issue STEM OPTs. They cannot, students who go there will not qualify for STEM OPTs because STEM OPTs require that the student have a degree from a Department of Education accredited school. And it would also mean that people who have master's degrees from ACICS schools would not have their H-1Bs qualify for the master's quota. So these are two fairly major things if you have a master's degree from an ACICS recognized school. If you obtained your degree before the derecognition, so the derecognition took effect in December. If you obtained your degree before then, according to ICE, the institution has to be accredited at the time that your STEM OPT gets filed. So it is the filing date of your STEM OPT application that determines whether or not your previously obtained degree is still valid for the purpose of STEM OPT. So this is a pretty major issue that if you have a degree from an ACICS recognized school, you would be potentially in a tough situation with this new regulation.
Thank you, Hemant. Now, Michael, in 2012, I believe 14 million foreign nationals entered the country on B1 and B2 visas. And this year, in 2017, that number is expected to increase to 23 million people. And a lot of our Telugu people, their parents, they like to basically travel. And also we have a lot of Indian companies that send their employees on B1s. Now, is it possible today that you can briefly basically delineate what Trump has in mind under the leaked draft order that's not yet law, that's not yet signed, but I mean, based upon what we know, what's Trump's thinking on this B1 and B2 visa?
Well, he addresses the issue directly in the draft executive order. What he wants is for Secretary of DHS to initiate rulemaking procedures that would help clarify what activities not permitted by people on these visas, and to make sure that people who enter on these visas, aren't engaging in skilled or unskilled labor, as required by the status of those visas. These B1B2 visas, are really important to the U.S. economy, though. They help with, tourism, taxes, travel dollars, support airline, hotel, car rental, tons of industries, significant, contributions. However, the U.S. government does have a perception that they are prone to high abuse. Thousands of B2 visitors overstay in the U.S. each year, and there also is some perception of abuse of the B1 program by the Indian IT industry. So with respect to the B2 visas, we believe the Trump administration will adopt a country-specific approach administered at the consulate level. This would mean Bangladeshis, Pakistanis, similar countries would face more difficulty in getting B2 visas, as the statistics show that nationals of these countries have high rates of overstay. With respect to India, however, we don't expect any major changes. We think the U.S. government will continue to make B1 visas available to a large number of Indian nationals while making some minor program adjustments. In terms of B1 visas, we think there's going to be probably some more large-scale changes. We think that Trump's going to increase enforcement measures to protect the B1 program integrity. Some possible changes could include administrative site visits, consular phone calls to U.S. companies to verify the nature and purpose of these visits, more intrusive searches like with computers, cell phones, at U.S. borders, and possible revoking visas for perceived abusers, even company-wide potentially if there's repeat abusers, and also enhanced use of corporate registries.
Thank you, Michael. Now, coming to the H4 EADs and L2 EADs, that has been proven to be very popular for spouses of H1Bs and L1s in the country. Now, Trump's plan is to make millions of jobs available to U.S. workers. And at one time, he has indicated that he wants to make available 25 million jobs to U.S. workers. Looking at the kind of statements that he has made, he has to basically get these jobs from someone and somewhere. And I think that with the H4 EAD and L2 EAD, is there any potential for these EAD categories to be repealed or reformed in some way? Can you elaborate on that?
Yes, I think it's unfortunately probably highly likely that Trump is going to take some action for EADs, particularly probably for H4s and L2s. Trump, as I said, his big goal is, promoting jobs for U.S. workers, and people with EAD are, competing with U.S. workers for jobs, and even though the number of workers isn't a huge number in terms of the 25 million, it's an easy target, and especially with EH4s, they were only recently, allowed to have EADs. It seems like a pretty easy target and one that probably won't face as much opposition as maybe some other programs if he wants to restrict those. So I think we could probably expect H4 L2 EADs to either be revoked entirely, or more restrictions, possibly some other programs. DACA, he's made statements about, I think as of now, not going to end DACA, but he doesn't want to renew it, and I don't think those group of people are going to be able to extend that.
Right. Well, thank you, Michael. Now, in terms of, we have talked about a lot about what kind of new laws and can come into the picture. Now, how about talking about how Trump's administration plans to use the existing laws, whatever existing laws that there are right now? How does he basically plan to use these existing laws to achieve better program integrity and better enforcement, so that, again, the objective is that more jobs could be made available to American workers?
Well, I think one key action that he can take is to, and his agencies can take, directing agencies to investigate, compile statistics, reports on various immigration, employment matters, so that he can have numbers, to back up claims that there's abuse, that these programs really need reform, and specifically in the draft executive order, he targeted H1, L1, and B1 holders as programs that he wants Department of Labor and Department of Justice, other agencies to look into, publish reports, and it's likely that whenever those reports are drafted, published, that he's going to use those to potentially initiate criminal and civil penalties against the abusers, and also as a basis for future reforms. He is, meeting with industry representatives, plan to meet with Indian IT tech representatives soon. So we're hopeful that once he gets the full picture of the employment needs of this industry, he won't make any measures that are going to be too drastic, too detrimental to the U.S. economy, because otherwise, if he's just going on gut reaction, these are bad programs, he can not only hurt foreign workers, but also U.S. workers, which would be, antithetical to what his main goal is. And as well as his agency heads, he has a number of enforcement actions that he can direct the agencies themselves to do. Obviously, some of these are going to require higher resource, more resources, so there could be more fees that are required, or restructuring of budgets. But administrative site visits, check for compliance are probably going to happen, increase. Heightened fraud detection, also likely labor audits, investigations, I-9 compliance, taking advantage of current equal opportunity laws to go after H1B employers, demanding higher level of scrutiny from USCIS in order to increase the number of H1B RFEs, notice of intent to deny, notice of intent to revoke, and revocations themselves. He can also issue consular officials to take actions such as, or at least advise that they have a higher level of scrutiny to issue more frequent visa denials, more frequent issues of 221G notices, more referrals to the Kentucky Fraud Protection Unit, and revoke approved petitions altogether.
Well, thank you, Michael. Now, Hemant, we have heard quite a bit about this H1B legislation, regulations, rules, a lot of different things. One thing that has really been missing in the press is the H1B quota. Now, April 1st is coming, and there are tens of thousands of new grads with newly minted OPTs and STEM OPTs that want to get through the H1B lottery. And also, I'm sure that there are tens of thousands of people from all over the world whose employers want to initiate H1Bs, and would like for they would like to basically go ahead and apply for the H1B lottery this year. Could you, I mean, I've heard that there is something going on in terms of litigation with the H1B lottery. Could you basically tell us what the H1B lottery is about and what can happen this year?
Well, ordinarily what happens is every April there is the H1B lottery. So, there's a cap on the number of H1Bs that is allotted in every year. There's 65,000 H1Bs and then there's 20,000 more under the master's cap. But what happens every year is that there are much, much more H1B petitions filed than there are H1Bs that are granted. So there are like over 200,000 petitions that are filed, and only, this 85,000 can be granted. So what happens normally is the USCIS conducts a lottery by which these 85,000 slots are randomly assigned to 85,000 random petitions. But what is happening now is that there is a case in Oregon. It's called TENREC v. USCIS. TENREC is a company that is suing the USCIS, saying that the lottery is illegal. And the reason they're saying that it's illegal is because the statute that gives the USCIS the authority to grant H1B visa, the language in the statute says that the H1Bs are supposed to be processed in the order in which they are filed. So it's supposed to be, according to the statute, a first come, first served type of thing. But in practice, it is impossible for the USCIS to do this because, on April 1st, they received over 85,000 petitions essentially at the same time. So it's impossible for them to know which one comes first or whatever. So that's why they use a lottery. So, but, the company is arguing that they should not be allowed to do this. And up to this point, they've still not ruled on this, but up to this point, what is happening is it appears that the judge is favoring the arguments of TENREC, the company who's suing. And if he rules in TENREC's favor, what will happen is that the USCIS will be ordered to process these in the order in which they were received. And what that would mean is that they would most likely be directed to go back to the petitions that were filed last year and give those in order based on the order in which they were received. Now, this would cause a significant amount of chaos in the H1B allocation procedure. So what will most likely happen if the judge rules in TENREC's favor is that Congress will act. Congress will pass some sort of bill or something like that that would allow the USCIS to continue using the lottery or use some other form of allocation that would not completely throw everything out. But this is something we're keeping an eye on because it has the potential to really drastically change the process, and it could have a major impact on people who are filing this year if they're expecting to try to get H1Bs through the lottery.
Thank you, Hemant. Now, in ending, I don't want to basically end with a lot of doom and gloom. I know that Trump has basically made some extreme statements on immigration, and he seems to be a person who wants to basically dig in and try to basically force people or try to force the system to change to his beliefs and perceptions. But now that he's elected and he's become a president, he would have to basically work with many aspects. I mean, this is a democratic process. He has to basically work with Congress, and Congress basically is answerable. All these congressional senators and representatives are answerable to their constituents, and many of them are tech companies. Now, the U.S. government basically also has diplomatic relations with India and other countries in this Committee of Nations, and there's a lot of give and take. in terms of, I mean, geopolitical risks, geopolitical security situations. Accommodations have to be made for Indian IT companies. Now, could you basically, I mean, kind of let our audience know that it's not whole doom and gloom, and that it's going to be probably more like a give and take when we see some final comprehensive immigration reform. I mean, there are going to be some possibly perhaps good things like elimination of per country, preferences, and there may be some, I mean, extra regulatory provisions in the H1B.
Sure. So, I mean, Trump, throughout his campaign, he was campaigning on this idea that immigration hurts America. But the reality is, first of all, there are two things to keep in mind. Trump is not the king. He's only the president, and there are lots of rules that limit what he can do. The other thing is immigration benefits society in many ways. So especially high-skilled immigration like H1B, it benefits the economy in many ways. There are a lot of businesses that rely on these, and these businesses have lobbyists, have contacts in Congress, they have contacts in the administration, and they will be involved in this process to influence what's going on. So ultimately, what actually gets put forward will have influences from all these people who understand that there are many benefits that America gets from this immigration system. So Trump cannot simply, even though it seems that way based on the way things have been reported, Trump cannot simply sign something with his pen and kick everybody out of the country. It's not going to happen. So there are going to be lots of stakeholders who have input, and most likely whatever they come up with, there may be a few more hurdles, but they are all hurdles that we can navigate and keep doing what we've been doing.
Thank you, Hemant. I'm happy to end on a positive note. At least, I don't expect that it would all be doom and gloom. There will be some serious challenges, but I think that these are challenges that we can certainly navigate. Well, thank you. I'd like to basically thank our audience for being on this presentation. We would follow up this presentation with a question and answer session.
Ravi, yeah, this is a permission, and we ran over 40 minutes above our allocated time for the presentation. But anyway, thank you. And before jumping and before taking the questions, just on behalf of ATA, I would like to appeal to all the attendees, please, take a membership in American Telugu Association, ATA. All these organizations will survive and with the support of the members, So if you become a member, it costs you $100, okay? So if you become a member, you have so many advantages. We are providing free IT training, and also for the students, we are helping them in emergencies and in some unfortunate incidents. And there are many programs, helping the back home for poor people, and also in our business community. Business committee that they are arranging a business network sessions and mentoring for small business and startup companies, and investment opportunities in startup companies too, and also during our conventions we are conducting the business idea competitions, but we are planning to do that even non-convention years also. And there are many. We are particularly, we are starting few other benefits for the international students. We'll be announcing that very soon. And IT training, the recent past few months, we provided on a Hadoop, a big data training, just for free, being a member. So, if you have to take on your own, it will be, anywhere from at least $500 to $1,000. Right, and again, a few other courses are coming up within a few days, within short period of time. We are going to announce, and we can take advantage of that. And there are many more, many more advantages. Also, not only that, if you are a member, and you can take, reduced discounted prices at local businesses and many other places. There are so many benefits, So I highly encourage you to, take up the membership in ATA. You can take the membership at, ataworld.org. There are many more benefits I can go over, but we are running out of time, so that I'll, just. I will stop here. And Ravi, so let's go to the questions next. So I read quite a few questions while you are presenting.
Right.
So there are very few generic questions. We are an H1, we are an F1, we are an OPT. Can we travel to India in these circumstances? Can we go and come back?
I would say absolutely yes. They can go and come back, but with some caveats. First of all, I would like to say that this is the information that I present is of general information, because I'm not completely sure of the particular situation of the attendees here. So it cannot be construed as legal advice to a client, but as legal information. And based on the caveat, I will attempt to basically provide information with regard to the questions that have been presented. Now, for people on H1B, let's say if you are working at a client site and if you want to go to India and you have a visa to come back, you should not have problems coming back with a visa. Now, if you don't have a visa and you need to go for stamping, you need to basically make sure that you have a client letter. Without a client letter, you could still be issued a visa, but it's going to be delayed at the consulate level. You are probably going to see anywhere from 3 weeks to about 3 months delays at the consulate level. So unless the end client is okay with that kind of a delay, I would basically say, don't go. But if you have the end client letter, you have basically reviewed your entire H1B file, the I-129, how was it filed, the support letter, then you should not have any problems in going and getting a visa stamping. That's for H1B. For people who, with H1Bs who work in their own employer offices, who are basically supervised by their own employers, again, they should not have a problem in going and applying for a visa at any of the Indian consulates or coming back with an existing visa. Now, for all non-immigrant categories, the CBP can be especially active. So what the CBP will probably do is they will, for any, whether you are on H1B, whether you are on F1, whether you are on B1, whether you are on B2, or even the CBP is probably going to, look at your intent more closely, and they would probably go and check your luggage, most likely your computers and laptops and cell phones. They want you to basically have you open your email, and they want to basically see what your intentions are. I mean, if you are coming on B1, are you basically telling your friends that you want to basically go to school on F1? Are you basically telling your friends that you would change to H1? They are going to basically want to have you open your laptops and see. If you are coming on H1, are you basically saying that you would be working at a different client site or for a different employer? Those are things that the CBP want to see. So make sure that whatever you are carrying does not contradict the information that is in your H1B petition, that is in your F1, that is in your F1 I-20, that is in the B1, that is in the B1 support letter. It has to basically be consistent. So the easiest way is for the CBP to stop you, check your cell phone, check your computer, and then basically seek to do some expedited removal, saying that you have made a misrepresentation of your intent, and to have you basically to charge you with fraud or misrepresentation. I would basically, counsel pretty strongly on that. But again, if you are on H1, should not be a problem for you to travel and get a visa and then come back. The same is with F1. You should not again have a problem as long as you have, as long as you basically have maintained a full course of study, as long as you have not violated your status, you should not have, and as long as you are able to show that you have the ability to pay for your finances here in the country, you should not have a problem in terms of going and getting a stamping and coming back.
Yeah, similarly, the pertaining question, the people can they go on vacation to Cancun or somewhere in Mexico and come back safely given the circumstances, the relation of US with Mexico, people are asking, but
Right. Well, Trump basically, Trump wanting to get these millions of jobs back into the US, obviously, where is he going to get it from? But from Mexico, because that's where a lot of these jobs have gone to the NAFTA trade treaty. So they want to basically rework the NAFTA trade treaty to their advantage, or at least they want to basically start, exerting more pressure to see if Mexico would kind of, agree to a more, I guess, what the Trump administration thinks is going to be a fairer deal. But that is trade relations between US and Mexico. As long as the Indian, if these Indian nationals are going to go to Cancun, the only thing that they would have to basically, when they go to Cancun, is do they have H1B specialty occupation work here? Do they have a client letter that establishes the existence of specialty occupation work? Do they qualify for a specialty occupation? Now, if they have a degree in information technology or computer science, or a directly related field of study to computer science, and they are working as a software engineer or an IT professional, they should not have a problem. But if you have like a degree in botany, biology, commerce, accounting, and you want to go to Mexico and say that I have an IT job, then you may run into problems. You may run into problems. You may not be able to basically get a visa. The same goes for Canada, any of these contiguous countries. So you'd have to basically show that you are clearly qualified, that there is clearly a job position, that the employer has been paying you your salary, and you should. Now, when you go to any of these consulates, they basically look at your credibility. How credible are you? When you talk to a consular officer, they want to basically see, okay, is this guy basically going to be doing this job? If they have any questions about your credibility, they are not going to be issuing you a visa. So again, if you have clean documentation, should not be a problem.
Okay, in another question, a general question, as summing up, many people ask this. Right. The people who graduated from ACICS accredited institution before December, can they apply for H1B in master's quota?
From what I have seen, they would have a hard time doing that, because the H1B requirements, I believe one of the requirements in the H1B in order to get into that master's quota is that wherever you have your master's from has to have recognized accreditation. And because the ACICS is no longer recognized, the places that with the universities that were previously covered by ACICS accreditation would no longer qualify. Now, there is one caveat that you should also know about this, which is that the Department of Education has given those universities an 18-month grace period during which they can find another accreditor. So, for example, if you have a master's from like Stratford University, and a place like that has 18 months to find a new accreditor. So if they're able to find a new accreditor, then at that point, once they become accredited by a recognized accreditor, then the degree that you earn from there would once again be valid for that purpose. But right now, because they don't have accreditation through a recognized accreditor, it would be difficult. It would be impossible for them to fall under the master's quota for H1B purpose.
Right.
So
Right.
basically,
Again, going back to the same question, in my personal opinion, at this time, I don't believe that it's a good idea to file it. People with schools with an ACICS accreditation to file under the master's quota at that time. That's in my personal opinion, because I think that if you are selected, or if a person is selected under the master's quota, and then during the adjudication stage they basically reject it because it's not from an accredited institution, then they are nowhere. They were not even considered under the regular quota. They could maybe have been, if they may have been lucky under the regular quota, but filing in the master's quota basically takes that away from them. And also, it's possible that even if the USCIS were to make a mistake and overlook it and approve it, then down the line, we have seen 2, 3 years, 5 years, 7 years later, the USCIS adjudicator can basically even come back and say, wait a minute, this is from an institution whose degree is not recognized by the USCIS, as an accredited degree, and therefore we don't basically recognize this as a US master's degree. It should never have been approved under the US master's category. So they could basically revoke it at that time, even if it's been approved at a later date. So there's a lot of based on all that information, I would lean on the side of not applying in the master's category, but I would encourage all of these attendees who are listening to basically take this up with their attorney and see what their attorney basically feels about it.
and same in addition to that, Ravi, so in other words, they need to apply on bachelor's degree.
Right.
Right. In case some of the universities might have accepted students with a 3 years degree, whereas in India, bachelor's degree is 3 years. Some of the universities might have accepted these 3 years candidates too. So, but if you don't want to use that master's degree from ACICS institution and you want to use a bachelor's degree, they have only 3 years degree. In that case, how they are supposed to apply? For applying for H1B, bachelor's has to be 4 years?
Well, it's a good question, Parmesh. Now, the USCIS, you don't need a 4-year bachelor's degree. You can basically apply with a 2-year bachelor's degree, a 3-year bachelor's degree. You can apply with a 10th class, intermediate. But what it is you need to have the equivalent of a US bachelor's degree through a combination of education, experience, and or training. So if you have a 3-year bachelor's degree from India, the USCIS takes the position that you should have at least 3 years of professional work experience. And it has to be a detailed work experience, and you should have basically the work experience letter should show that that your colleagues were all people who at least had the equivalent of a US bachelor's degree. So the letters have to be detailed, The letters have to show that your colleagues, the people you basically worked with, had U.S. bachelor's degrees. I mean, not U.S. bachelor's, the equivalent of U.S. bachelor's degrees. And based upon that, the attorney's firm or the employer can get a professional education and experience evaluation that would be acceptable to USCIS. Now, our firm basically has done, H1Bs for people who have failed 10 plus or may have had just intermediate degrees. If these petitions are done properly and if they have genuine work experience, it should not be a problem. We have even done cases where someone has just an 8th class degree, and we have shown that that is, with their experience, that has basically been equal to a U.S. bachelor's degree. So, yeah, I would strongly recommend those people with 3-year bachelor's degrees to get their experience here in the U.S. as well as in India, and show that with that, the 3 years of experience and their 3 years of education, it's equal to a U.S. bachelor's degree.
Right.
So
in another question,
yeah.
If a green card holder gets caught under DUI, so in term, what would be his future? Can he travel?
Good question again. A green card holder, or even I will basically go ahead and there are different. The law is different for green card holders and different for non-immigrants here. Now, for a green card holder, getting caught in a DUI by itself, one DUI is not a removable offense. Okay, it's not a removable offense, a DUI by itself. So, if you go to the, if you have a DUI and you go to India, you should be able to come back. Now, in the new Trump executive orders, there is some language that's a little concerning. Under the new Trump, the draft orders or executive orders, the ICE basically is required to remove, is required to basically initiate removal actions against any aliens who have committed crimes. But I believe that these executive orders were not properly drafted, because as of now and in the future, the DUI is not considered as a crime of aggravated, it's not considered as an aggravated felony, and it's not considered as a crime involving moral turpitude. So you cannot basically be removed from the country, and when you basically try to come into the country, you cannot be excluded by the CBP. Now, coming to people who are on non-immigrant visas, such as H1Bs, B1s, F1s, H4s, when you are convicted, or even when you are arrested for a DUI or for any other offense, under some changes that have happened in 2016, the U.S. State Department takes the position that your visa is automatically revoked. So they have a system whereby if you have an arrest, the arrest basically goes into the National Crime Information Center database, and it alerts the U.S. State Department system, and they automatically they go ahead and revoke your visa. So when you are in the U.S. and you want to travel to India, you can't basically, they won't allow you to come back with the same visa. Rather, you would have to go to the consulate and basically explain to them that you have been arrested, and that if you are arrested, you have to basically show them that you have been arrested and it's still going on. And for DUI, what they do is the consulate basically has you do a physical and mental, evaluation. They do your blood work, and if everything comes out okay, they most likely will issue a new visa and will let you enter the country. That would be for H1B people. I would assume the same thing would apply for F1s and B1s too. So my recommendation or my advice is, for if you have a DUI or if you have basically been arrested for any other crime, don't attempt to come back into the US based on an existing visa, because when you try to come in, the CBP here will stop you, or you may be stopped somewhere in UK or or at a pre-flight inspection facility in Dubai or something like that, and they will have you return back to India. To avoid all that, get a new visa and then come back again.
Right. This is another hypothetical question. If the so-called new bill, which is asking to increase H1 salary to 130,000, right? So
right.
If that bill passes, what will be the effect on existing people who are on H1B?
I would assume that if there is going to be a law like that, it would cover the existing people as well. But I would think, based on the 130 figure, I can tell you that the law is not going to be passed in that form. It would get seriously weakened, and we are looking more like $80,000 or $90,000, not $130,000.
Right, and another question.
But if the law were to be passed, it would probably most likely only apply to employees with H1B dependent employers. It would not apply to all employers or all people on H1B. It would only basically be restricted to those employees whose employers are H1B dependents, and we would probably most likely see the cap at $90,000.
And this ACICS accreditation questions, there are many of them.
Right.
Will it also affect already passed out students and their OPT extensions?
With the OPT extensions, I believe what the USCIS has said is that you need to you need the master's degree to be accredited at the time you file for that OPT extension or the STEM OPT extension. Unless the degree is accredited at the time of filing, and also at the time of having the petition adjudicated, they are not going to, unfortunately, they are not going to be approving these petitions. What would you say, Hemant?
Yeah,
anything to add?
No, that's correct. I mean, they've made it clear, ICE has made it clear that at the time of the filing that matters. So whether the institution is accredited when you file for the OPT extension, that is what determines whether or not it will be approved.
And another question, the people who are already on green card, getting citizenship, upcoming changes is going to affect in any way getting the citizenship, the people who are already on green card?
Well, I see two possible changes here. One is we may see some legislation where U.S. citizens, historically, U.S. citizens have been able to file green card petitions for their parents under the immediate relative category. Now, that has facilitated the kind of arrival of large numbers of parents, especially, for Telugu or for for U.S. citizens of Indian heritage, there has been large number of parents from India being able to immigrate on green cards. Now, the Trump administration believes that a lot of these older folks come in and they apply for benefits and social services, and they probably should not, be allowed to be to have the eligibility to apply as an immediate relative. So it's possible that they may basically restrict the ability of U.S. citizens to apply for their parents. It's possible, but again, I'm not sure. Now, your other question was?
The people who are already on green card applying for citizenship.
Right.
Is there anything that's going to change?
Applying for citizenship, they should not have any problems. Someone basically gets a green card through employment based, they have to satisfy the 5-year residence requirement. Out of the 5 years, they have to satisfy at least 2.5 years physical presence requirement in the U.S. And as long as these requirements are satisfied, they should be able to file and they should be able to get citizenship, the U.S. citizenship conferred upon them. Now, what has happened is that the USCIS has tried to go to a new system to adjudicate these naturalization cases. In, I believe, 2016, they started to basically use a system called ELIS. It was supposed to be a faster system and an easier system to adjudicate many of these USCIS petitions, but then they realized that there were some serious security risks in the system, and they realized that this security checks were not basically being conducted properly, especially the IBIS Interagency Border Information Systems checks, the FBI name checks, the Interpol checks. These were not basically being conducted properly by the ELIS system. So there are about 9,000, 10,000 people who are basically stuck, whose citizenship applications have been stuck, and USCIS is trying to convert them back into their older system, and it's going to take some time for them to basically take all their data that has been entered into the ELIS system back to the old system. So we are going to probably see some hiccups there, but generally speaking, I mean, we should not have any problem for a U.S. green card holder to file for a U.S. citizenship application at this time.
Right. Here is another typical, not typical, specific question. I am on F1 visa doing my PhD and applied for a post-OPT with the expected date of February 15th. By expecting I will submit my thesis by February, is there any problem in converting post-OPT to pre-OPT? Can you hear me?
Yes. I will have to basically do additional research on this matter. I'm afraid I can't provide any ready advice on this.
Oh, okay. Okay. Thank you. And
generally speaking, once you apply for a post-OPT, you cannot go back to pre-OPT. That's the general rule, unless you basically change your program, you go to a different program altogether. But within the same program, you can't basically do the change from a post-OPT to a pre-OPT.
right. Maybe it's a very generic question. It's not related in any way. Is Arizona State University is a good university for undergrad in computer science? Yes, it is. It's a good school.
Yeah. I think it's a very strong school.
Yes, yes, it is very, yeah. Okay. Ravi, you can pick up any questions if you want from the list.
I know that there are so many questions.
Right, there are more than 200 questions. As we said, if we can't answer all, I know, pretty sure we won't be able to answer them, but you know, we will summarize them and categorize them. You know, most of them are common questions, and then we can, you know, say as a put it as a FAQs. You know.
Right. So I have. So there was this question about an L1A who had to go to India on an emergency basis, and his daughter is a US citizen. Is there going to be any problems? Now, if he has an L1A visa stamping, he should not have any problem. And even if he doesn't have an L1A visa stamping, he can go for a new stamping. Well, at a new stamping, the consulate would probably have some questions in the sense that is he working in the L1A occupation? Now, Michael could probably provide some information on that.
On what exactly the
L1A parameters are.
Oh yes, so you know, assuming he has L1A, he probably satisfies this, but as long as he's working in a capacity where he is supervising other professional employees or managing an essential function of the organization, if he has hiring and firing authority or other personnel decision-making authority, if he has discretionary authority to make day-to-day decisions of the company, and if he primarily engages in managerial or executive duties, he should be fine in terms of L1A status. Managerial or executive. Right. That was mostly managerial duties.
So again, the question is that the consulate would basically examine whether he is functioning either as an L1A manager or L1A executive. If he can credibly show that he is working as an L1A manager or L1A executive, he should not have a problem.
Is the Dropbox for H1 visa still valid?
The Dropbox for H1B visas are, I mean, they are valid, but what we are hearing is that more and more, I mean, pretty much the consulates are basically having most of the people to come in for interviews these days.
Okay, here is another question. Removing visa hurdles for temporary visa holders. Please explain what benefits this provision will provide to H1B temporary workers. Providing employment and travel authorization to those with approved employment-based petitions awaiting visa availability, so that they similar under American Competitiveness in the 21st Century Act. Removing visa hurdles for temporary visa holders, that is the topic. Please explain what benefits this provision will provide to H1B temporary workers. Providing employment and travel authorization to those with approved employment-based petitions awaiting visa availability, so that they similarly under American Competitiveness in the 21st Century Act. I'm not sure.
Right.
Is it referring to I-140 portability?
Right. They are referring to I-140 portability, and again, I would have to basically take this under advisement for further research.
Okay. Okay. as an H1B EB2 holder with an approved I-140 who was given a 221G in Chennai despite I-140. Is it safe to travel to Jamaica for stamping?
Well, I think that the U.S. consulate in Jamaica is going to be rather hesitant to approve a visa for that the U.S. consulate in Chennai, basically which is presumably based in his home country, has declined. So based on those facts, I would think that even if he were to travel to Jamaica, I don't think that he or she would be able to have a visa approved.
Okay. My I-140 is approved. I got the approval copy too, but still status showing as case was sent to the Department of State. What it means?
Well, there are two options. I mean, this means that his I-140 is approved and he doesn't have to worry at all. That's the first thing I would say. Nothing to worry about, his I-140 is approved. Second thing is that when a lawyer files an application, they can basically specify whether the foreign national is going to be filing a 485 or whether they are going to basically be filing for a consular processing. Now, the law firm may have made a mistake in checking the consular processing box. That may be the case, but that mistake will not cause any problems to his adjustment of status filing or to his existing I-140.
Right. H1 amendment still applicable when change location?
H1 amendment still applicable when an employee locations that's not within the same metropolitan statistical area, then the employer has to basically file an amended petition under the post-Simeo memo that the USCIS basically provided in, I believe, April of 2015. H1B amendment not denied. I have my H1B valid till 2019. Well,
yeah, it's not clear what. Okay.
So if the H1B amendment got denied, H1B is valid till 2019. The H1B is valid, assuming that particular H1B is not withdrawn, not revoked. It is valid. So what that means is that the person is not accruing unlawful presence for the purposes of the 3-year or 10-year bar under the IRA. But however, that person would have to basically be employed pursuant to the terms of that valid H1B visa. If the person is not employed pursuant to the terms of that valid H1B petition authorization, the person is deemed to basically be failing to maintain status. In other words, it's a status violation not to be working under the terms of an approved petition and staying in the country, but it does not create unlawful presence.
I am graduated from ACICS. My degree is valid.
I'm not sure what ICS means.
No, ACICS. Graduated from means at the accredited institution, one of the institution. Is my degree valid?
Well, the degree may be valid, but not for U.S. immigration. It may be perfectly valid for employers. You know, the employers may basically say that that degree is the same as a U.S. master's degree. But as far as U.S. immigration is concerned, they say that we won't accept it for eligibility for the H1B US Masters quota. We won't accept it for eligibility for STEM OPT, and we won't accept it for eligibility for the EB2 I-140. But those are the main things with the loss of the derecognition by USCIS of the ACICS accreditation.
Right. This is a hypothetical cum practical question. I am on F1. This is the second year and planning to apply for H1 this year. On full-time employee, they are offering me 80K. If the 100K bill passes, what would be my option? Oh gosh, he's offering 80K is lots of money. When we got offered 30K when we graduated.
Right. I don't think that it's kind of rather premature to be able to be anxious about this. I think based upon, I mean, it does appear that he's going to be okay. He or she is going to be okay.
Yeah. My suggestion would be grab it. If you offer 80K for starting salary, just grab it. Next is next. Is travel to Mexico advisable for non-STEM F1 students? I'm not sure. This is.
Now, when you go to a country other than your home country, the main thing is that they don't understand what your degrees are, and so you may have a BCom, they may not have an understanding of what a BCom is, or you may have a BCom with a CA, they may not understand how a BCom with a CA is equivalent to a US bachelor's degrees. So when you go to these third countries, these countries, either contiguous countries to the US, or other countries, I want to basically, I advise my clients that their documentation should be completely clean.
Can we file for H1B for master's quota where the consulting company is operating from home and the employee is working at client site? In this case, what company address to put on LCA, where to post the LCA notice?
Right.
Interesting question.
Interesting question, but it's, I mean, a lot of companies are small mom and pop operations. The LCA would basically have to be posted at the home location, and the work site basically has to be listed as the work site at the client location. The H1B petition can be filed, should not be a problem, but my suggestion is get a good attorney to file it. Okay. We have about 3 minutes left. Now, a lot of these questions, people can basically go ahead and either send me emails at ravi@mannamlaw.com, or can make consultations, set up consultations at our website, www.mannamlaw.com. That's mannamlaw.com. A lot of these are very interesting questions, and I would love to answer them. Not a problem, and would like to basically help out in any way that I can. So either they can send me an email with a possible phone number, or they can basically go to my website and try to set up a consultation.
There should be a slide. Can you put on the slide on?
Well, yeah, try to do that. Slide. Right.
Yeah. And also, if you have any questions, you can email to the info@artaworld.org, regarding any membership or contacts for the Mannam and Associates. Ravi Mannam will be our, the Immigration and Law Committee Chair, always he will be in touch with us. And we will be doing more of these webinars in the down the road. If any executive orders or typical bill passes, that time also we can have another session. But yeah, so we left with 1 minute if you want to answer any other question, quick question.
Well, what I basically tell my clients is that it is easier to go through a straight path. Don't try to bend rules. Don't try to basically do any shortcuts. Present the information as it is and get good legal help. Don't rely on your friends, but legal help may be a little costly, but get quality legal help. That's I have been in this industry for a long time, and ensure that your lawyer basically understands understands about your industry and understands about your background. If you have a pharmacy degree and you want to basically get into an IT job, your lawyer should be able to understand how this pharmacy and information science basically are, how this discipline of pharmacy informatics basically exists, and what you can do with the pharmacy degree as a business analyst. So your lawyer should basically have that basic understanding of your occupation. And
yeah. You can still continue.
Well, again, I'm not sure if I'm still online, but
so we are done, and thank you very much, Ravi, for your time and helping all these people. And yep, again, from ATA side, I request you to enroll in ATA membership. Go to ataworld.org, and there are many more benefits and free training programs, and there are many more. We can we can give out all the details. So we don't want to take too much of your time. Thank you once again. Thank you.
Wait.
Thank you, guys. Thanks for attending. This is Karna Grassley, President, ATA. Going forward, we're going to conduct similar kind of webinars. So please stay tuned. Thank you.